Part 3. Proceedings in a suit in Chancery, from the appearance of the defendant to the close of the pleadings. Chapter 12. Appearance and Defense. Article 1. Appearance by the defendant. 222. What is an appearance? The subpoena and the notice by publication require the defendant to appear on or before a day named before the Chancery Court to answer the complainant's bill. What is meant by appearing is not coming bodily into the courthouse when and where the court is in session, but making some motion or doing some act of record in a cause or filing with the clerk and master some written defense to complainant's suit. This motion, act of record, or written defense the defendant ordinarily makes through his solicitor, but he may make it in person. Unless a defense is made in the manner and time required by the practice of the court, a judgment pro confesso will be entered against the defendant. An appearance is, then, any act whereby a defendant recognizes the jurisdiction of the court in the particular cause wherein he is a defendant. This appearance, or recognition of the court's jurisdiction, may be 1. A limited or special appearance, or 2. An unlimited or general appearance. A limited or special appearance is ordinarily made for the express purpose of disputing the jurisdiction of the court, and the appearance must affirmatively, or necessarily, appear to be for such limited or special purpose as, for instance, to plead an abatement, or it will be deemed to be an unlimited or general appearance. A general appearance is one that is not expressly or necessarily limited to the particular matter, motion, or pleading constituting the appearance. All appearances are deemed to be general or unlimited, unless expressly declared to be special and limited, or unless its special or limited character is necessarily implied from the nature of the motion or pleading constituting the particular appearance in question. A defendant may appear voluntarily as soon as the bill is filed, and without waiting for the subpoena to be served on him. This is sometimes called appearing gratis, and is generally resorted to when a defendant wishes to make some immediate application to the court in the cause, or to resist some application by the complainant. A defendant who so appears has every right he would have had if subpoena had been served on him, returnable on the day he voluntarily appeared. Thus, an appearance to have pro confesso set aside is not such an appearance as will debar a defendant from pleading in abatement to the bill. 223. What constitutes appearance? In practice, the service of a subpoena on the defendant is equivalent to his appearance at the time and place specified in the writ, and it is only when there has been no personal service of subpoena that an actual appearance by the defendant becomes important. A defendant may be brought before the court by attachment of his property and publication in a newspaper, or, in some cases, by publication without any attachment. But such devices are only substitutes for actual notice, and are allowed only because otherwise there would often be a failure of justice. In all such cases, courts proceed with uneasiness and misgivings, they realizing that it is the manifest right of every one who is sued to have a reasonable notice of the suit, and a fair opportunity to make defense. For this reason, courts yearn for some evidence that a defendant brought before the court by publication has actual knowledge of the litigation, and they seize, with some eagerness, upon any act of the defendant recognizing the jurisdiction of the court over him, in the particular case. Hence, the filing of any pleading, the making or resisting of any motion, the filing of exceptions to a master's report, the taking of depositions to he read in the cause, the making of any agreement with the complainant or his solicitor relative to any proceeding in the cause or any other act in the cause, between the filing of the bill and the rendition of the final decree, whereby the pendency of the suit is recognized expressly, or by necessary implication, will, if there be record evidence of the fact, constitute a general and unlimited appearance, unless limited by express declaration or necessary implication, in which case the appearance will be limited. In all cases of voluntary appearances, where no pleading is filed or motion made by the defendant, in order to avoid disputes or misconstruction, it is proper to have some entry of record in reference to the defendant's appearance. Such entry, however, is not indispensable, for the courts will not permit a party who appears to have had actual knowledge of the pendency of a suit against him, to complain because he was not formally notified. Courts of equity regard substance, not ceremony, and actual notice is the substantial thing, and not the ceremony of notification. 224. Effect of an appearance. As the object of process, whether by subpoena, or by attachment of property and publication, or by publication alone, is to notify the defendant of the pendency of a suit against him in a particular court. It follows that the actual appearance of the defendant cures any defect, omission, or imperfection in the process or in its execution. Indeed, if the defendant actually appears, it matters not whether any process in faute ever issued at all. And when a defendant does any act, indicating unmistakably that he recognizes himself as a party to the particular suit, he is conclusively deemed to have knowledge of the contents of the pleadings, and of the whole record in the cause, including all that has been done in it, and he conclusively waives any irregularity or informality in the process whereby he was notified of the suit, and indeed waives the process itself. Appearance in an attachment suit gives the court jurisdiction of the person if the defendant, but not of the property sought to be attached. The latter depends on the validity of the attachment proceedings. A regular guardian can waive process for his ward, and so can a husband for his wife, when they are living together and her separate estate is not involved in the litigation. A partner can, while the partnership exists, enter the appearance of his firm, but not after its dissolution. Infants and lunatics can neither enter an appearance nor waive process, and all proceedings against them not based on proper process, properly executed, are void. There can be no guardian ad litem appointed for them, until after such service of process, and until the return day thereof, and, therefore, a guardian ad litem cannot enter their appearance or waive process for them. But where the court has no jurisdiction of the subject matter, an appearance by the defendant does not give the court the right to proceed and pronounce a decree. If, however, the objection to the jurisdiction is merely local or personal, such objection is waived by appearance and defense to the merits, except in suits relating to land. 225. When a defendant served with subpoenas bound to appear. A defendant is bound to appear at the time and place specified in the subpoena or publication notice. This time is not uniform throughout the state, because by statute, original process may, by rule of court applicable to the court where made, be returnable to the rule days, and all others except final process may be so returnable. In pursuance of this statute, in many of the counties, there is a Chancery rule providing that all process, except final process, shall be made returnable to the rule days. Where there is no such rule of court, all original process is returnable to the first day of the regular term, and service of the original subpoena on the defendant 5 days before the return day binds him to appear within the first 3 days of the term, if the court holds so long, otherwise on the first day of the term. But if the subpoena be served upon the defendant within 5 days before the first day of the term, he is not bound to appear before the first day of the second term after the service, unless the term lasts longer than 1 week and the subpoena is made returnable to some subsequent day of the term, in which case he must make his defense within the first 3 days of such return day, or be liable to a pro confesso. And if the subpoena is made returnable to a subsequent day, as stated, but executed within the 5 days before the return day, then the Monday succeeding such return day becomes the return day, and the defendant is allowed the 3 succeeding days thereafter to make defense. Under these rules, if the subpoena is served on the defendant on the Wednesday next before the return day, such service would be in time to require the defendant to appear on such day, or on the Tuesday or the Wednesday next following. And if he failed so to appear, a judgment pro confesso could be entered against him, in open court, on Thursday morning. The defendant in such case has all the first 3 days in which to appear and make his defense, or to obtain further time for that purpose. But if the court hold less than 3 days, the defendant is bound to appear and make his defense on the first day of the term, and the business of the court has been finished within 3 days, and the court is about to adjourn on the second or third day of the term. a pro confesso may be taken against him if he has made no defense. In such a case, the order may be in the following form, omitting the title of the cause. Order pro confessio on second day of term. In this cause, on motion of complainant's solicitor, and it duly appearing to the court that the defendant, Richard Roe, is duly in court by service of subpoena, or by publication, and that he has failed to appear and make defense to complainant's bill within the time required by law, and the court being about to adjourn, it is ordered that complainant's bill be taken as confessed by him, the said Richard Roe, and the cause set for hearing ex parte, and in a proper case, a final decree may be taken and entered at the same time. See ante 205. When the subpoena is returnable to a rule day by a rule of the court, the defendant has all of the return rule day in which to file his pleading, and as no pro confesso can be entered against him until the next succeeding rule day, he has all the intermediate time in which to file his pleading. It must be remembered, however, that each day of the term, as well as the first Monday of every month in vacation, is a rule day, and a rule day for all rule day business. And if a term of court comes between the return rule day and the first Monday of the next month, a judgment pro confesso may, for want of a defense, be entered on any day of such term. The return days of all mean process in the Chancery Court, such as subpoena to answer supplemental and amended bills and bills of reviver, shall be the rule days of the court. And in such cases, the defendant must file his written defense with the clerk and master before the rule day next after the return rule day, or a pro confesso may be entered against him on such next rule day. But if a term of court should begin before such next rule day, the pro confesso may be entered on any day of the term, inasmuch as every day of a term is a rule day. But alias or mean process taken out at any time may be returnable to any Monday of the term, and if executed 5 days before the return day, the defendant has the first 3 days of the term, if the court holds so long, otherwise the first day of the term to make defense, or obtain time therefor. And after said 3 days, or 1 day, as the case may be, the cause stands to be proceeded in for all purposes. If such alias or mean process be executed within the 5 days before the return day, the succeeding Monday becomes the return day, and the cause stands to be proceeded in at that term. 226. When a defendant brought into court by publication is bound to appear. When the defendant is brought into court by attachment of property and publication, the last publication must be at least 1 week before the time fixed in the published order for the defendant's appearance. If therefore the time so fixed be the first day of the term, and there be less than 1 week between the last publication and the first day of the term, it would seem that the defendant is not bound to appear until the first 3 days of the second term of the court after such publication. But if the appearance day is a rule day, then the defendant need not appear until the rule day coming at least 1 week after the last publication, and he has all of such rule day in which to make his defense. When the defendant is brought before the court by publication, without any attachment of property, the 4th publication is equivalent to the service of the subpoena on the day of such 4th publication. And if 5 or more days elapse between the day of such last publication and the rule day specified in the published order for the defendant's appearance, then such rule day is his day for appearance. But if less than 5 days elapse, then the next succeeding rule day is his appearance day. In all such cases, the defendant has all of the appearance day in which to make his defense, and no pro confesso can be entered against him until the rule day next succeeding the appearance day. If, in any case, the defendant has a demurrer, plea, or answer properly filed, no pro confesso can be entered against him, even though he may have been in default when such pleading was filed. And if in any case a term of court comes while a defendant is in default, a pro confesso can be entered against him on any day of such term, unless he filed a proper pleading before the motion for such a judgment was made. 227. When and how defendants under disability appear. As already shown, minors and persons of unsound mind must be brought into court in the same way as defendants not under any disability. But as minors, idiots and lunatics cannot bind themselves by any contract, and, as a consequence, cannot retain counsel. And as they are incapable of making their own defense, the law of the court requires that they should appear by regular guardian, when they have such. And, if they have none, it becomes the duty of the court, or of the matter, if the court be not in session, to appoint a guardian for them, for the purpose of the particular litigation. This guardian is called a guardian ad litem. Neither the chancellor nor the master can rightfully appoint a guardian ad litem unless 1. The infant, idiot, or lunatic is made a defendant to the bill, and 2. Is duly in court by service of subpoena, or publication fully made. The court must have actually acquired jurisdiction of the person of the infant, idiot, or lunatic before a guardian ad litem can be appointed, and this jurisdiction can be acquired only by proper service of proper process, and not then until the return day of such process. For, until the return day, the process is, in contemplation of law, in the sheriff's hands, and the court cannot know whether it has been duly served or not. And besides, the party served is not required to appear until the return day of the process. Hence, any appointment before the return day would be premature. An infant without a general guardian does not become a defendant to a bill, unless 1. The bill names him as such, 2. Process has been executed as to him, and 3. An answer filed for him by a guardian ad litem duly appointed. If a married female defendant is a minor, or of unsound mind, she must appear by a regular guardian, if she has one, and if none, a guardian ad litem must be appointed for her. In such a case, however, her husband is generally appointed her guardian, when she is a co-defendant, unless they are living apart, or her interests are antagonistic to his. If a married female defendant is of age, and of sound mind, she, ordinarily, appears with and by her husband, who must see to it that her answer is put in jointly with his. If, however, their interests or feelings are antagonistic, she may, if she or he choose, appear and answer separately. 228. Where a defendant, or other person summoned, is bound to appear. When a defendant, witness, or other person, is subpoenaed, or in any way notified by service of process, or by publication, or by an order of record, to appear before the court, the place for him so to appear is in the office of the clerk and master of the court, who is authorized by jaw and the practice of the court to represent the court, pro hac vice, and who will, on due inquiry, inform the person so appearing what is required of him, so that he may order his movements advisedly. A person does not, ordinarily, appear before the Chancery Court in propria persona, unless he does so 1. To manage his own case, or assist his solicitor therein, or 2. Is under arrest, or on trial, or 3. Is a witness examined in open court, or 4. Is present in reference to the execution of some bond or other instrument, or the solvency of the sureties of some party. A party appears before the court, as a rule, in the person of his solicitor, and whatever paper he wishes to present or file, and whatever motion or argument he wishes to make, and whatever protest or request he desires to submit, and whatever other action he feels called on to take, in reference to any matter before the court, is, usually, done by or through his solicitor, either in the office of the clerk and master, or in open court, as the exigency may require or convenience suggest. Article 2. Defenses generally considered. 229. Proceedings preliminary to making defense. When a defendant is notified by service of subpoena, or by publication, that a bill has been filed against him, his first duty is to employ a solicitor of the court in which the bill is filed, to represent him, unless he intends to defend in peron. He must be careful to make defense within the time required by law, or a judgment pro confesso will be entered against him. If he has not been served with a copy of the bill, he is entitled to a copy on demand. He is, also, entitled to see the original bill, and the exhibits thereto, if any, but he has no right to take them out of the office of the clerk and master. The employment of a solicitor by the defendant is ordinarily verbal, but where the defendant does not sign or swear to his answer, the better practice is for the solicitor to obtain from the defendant a written authority to appear for him in the cause. However employed, the solicitor has all the rights his client would have, and may have a copy of the bill and an inspection of the original bill and the exhibits. But he has no right to take any of them out of the office, without the express permission of the court or the clerk and master. Having read the bill or obtained a copy, the defendant or his solicitor will, with all diligence, possess himself of the real facts in the case, and especially of the matters relied on as a defense. 1. If there be any ground for disputing the jurisdiction of the court, a plea in abatement must be filed before any other defense is made, or offered to be made, or even before any motion is made in the case. 2. If, on inspecting the bill, it shows a manifest want of equity on its face, or if any prerequisite of the writ be wanting, he may enter a motion to dismiss the bill, provided the defendant is subpoenaed to appear on the first day of the term. If, however, he is subpoenaed to appear at a rule day out of term, this motion is not available, as it cannot be made except in open court. 3. If the bill be demurrable, the demurrer must be drawn and filed, taking care not to apply it to the whole bill, unless so intended. 4. If none of these defenses can be made, but the bill is liable to be defeated by a plea in bar, such a plea is the next defense in order. 5. If such a plea is not available, or if available is not advisable, then the defendant must answer the bill or disclaim. And if an answer will be insufficient to enable him to make complete defense, or to obtain all the rights he is entitled to arising out of the controversy, or the subject matter thereof, he may. 6. File his answer as a cross bill, or, if it is necessary to bring new parties before the court, he must file a separate cross bill. 7. If the bill is made up of several distinct matters, and a demurrer will lie to a part of it, a plea in bar to another part, and an answer can be made to the remainder, the defendant may join all of these defenses, and may, in addition, file a cross bill if he needs any affirmative relief growing out of the subject matter of the litigation. The fact that all of the foregoing matters are involved in every defense, and that the various defenses must be made in the order stated, and that the making of any of the defenses is a waiver of all the defenses that precede it, show how important it is for a defendant to be diligent in employing a competent solicitor, and how diligent and cautious the solicitor must be after his employment. If there be any paper referred to in the bill as an exhibit and not filed, the defendant may have an order, by the master, entered on the rule docket, requiring such exhibit to be filed, and extending the time for answering until a reasonable period after the defendant is notified of the filing. 230. Defenses generally considered. The bill and the subpoena require the defendant to answer the bill. If, however, there are sufficient reasons, either inside or outside of the bill, why he should not answer it, he may avail himself of these reasons. These reasons, if outside of the bill, are brought forward by plea or by a motion to dismiss, which is, in such a case, in the nature of a plea. If the reason, however, are inside of the bill, or, in other words, apparent on its face, they are brought forward by demurrer, or by a motion to dismiss, which is, in such case, in the nature of a demurrer. If the defense thus made is sustained by the court, the bill is dismissed, unless the defect in the bill can be cured by amendment, in which case it may be amended on proper application. Some of the defenses thus set up do not reach the merits of the controversy, and though they may cause the bill to be dismissed, such dismissal will not prevent another bill being filed on the same grounds. But others of these defenses do go to the merits, and, if sustained, not only cause the dismissal of the bill, but also forever terminate the matters in controversy. The defenses which merely dismiss the suit without touching the merits are called dilatory defenses, because they only delay a decision on the merits. The defenses, which result in the decision of the controversy on its merits, are called peremptory or permanent defenses, because they result in a permanent determination of the controversy. 1. Dilatory defenses are those which insist, 1. That there are such irregularities in bringing the suit, or in selecting the venue, or in issuing or executing the process, that the defendant has the right to have the suit abated. and 2. That the court has no jurisdiction to determine the matters set forth in the bill. 2. Peremptory defenses are those which insist, first, that the complainant never had any right to institute the suit, or second, that if any such right ever existed, it is extinguished or ended. The defense that no right to sue ever existed includes the following: 1. That the complainant's rights are not superior to those of the defendant. 2. That the defendant has no interest in the controversy. And 3. That there is no privity between the complainant and the defendant, or any other right in complainant to maintain the suit against the defendant. The defense that if the complainant ever had any right to sue the defendant, such right is extinguished or ended, is based on the ground: 1. That the right to sue has been extinguished by the act of the parties themselves, or 2. That it has been ended by operation of some law. 231. Various modes of defense. The mode and order in which these matters of defense may be made are: 1. By disclaimer, a species of answer whereby the defendant disclaims all interest in the subject matter of the suit, and prays to be dismissed. 2. By plea in abatement, a pleading which one relies on some single fact outside of the bill itself, and also outside of the merits of the controversy, to abate the suit, or to denies some jurisdictional allegation. 3. By motion to dismiss, which is an informal and summary method of ending the litigation, and is based on the fact 1. That the bill is unknown to the forms of the court, or 2. That there is no equity on the face of the bill, or 3. That the court has no jurisdiction of the defendant or the subject matter, or 4. That someone or more of the prerequisites of the writ are wanting, or 5. That there is a misjoinder or non-joinder of parties, or 6. That the bill is multifarious, or 7. That there is some other statutory ground of dismissal. 4. By demurrer, a pleading which insists that, as a matter of law, the statements in the bill do not entitle the complainant to the relief prayed by him against the demurrant. 5. By plea in bar, a pleading which raises an issue on some single matter of fact touching the merits, which issue if decided in the defendant's favor will end the suit, or, at least, end so much of the bill as the plea covers. 6. By answer, a pleading which either denies the material allegations in the hill, or admits them, and sets up new matters which avoid them. 7. By cross bill, a pleading which brings such additional matters, or parties, or both, before the court as are necessary for the defendant's full protection and defense, or for a full adjudication of all the matters in controversy. 8. By adjoinder of any 2 or more of the foregoing defenses, when the bill contains distinct matters subject to distinct defenses. 232. Order in which defenses must be made. It is important for the pleader to keep in mind the order in which the various kinds of defenses must be relied on, inasmuch as a mistake, in this matter, may preclude him from availing himself of the only successful ground of defense open to him. The order of defense is strictly logical, beginning with the most technical and least meritorious kind of defense, and proceeding, by regular stages, to the least technical and most meritorious. The order of defense is prescribed by statute, and is in strict accord with the true logic of pleading. It is as follows. 1. Pleas in abatement, including, under this term, all pleas which seek to dispute the jurisdiction of the court over the person of the defendant or over the subject matter of the suit. 2. Motions to dismiss, including all the various grounds whereon the defendant seeks to have the bill summarily dismissed, without filing any written pleading. 3. Demurrers, whether to the whole bill or only to a part thereof. 4. Pleas in bar, comprising all pleas which do not dispute the jurisdiction of the court. 5. Answers, which also include disclaimers, whether the disclaimer covers the whole or only part of the subject matter of the litigation. 6. Cross bills, whether joined to the answer or filed as a separate pleading. The adoption of any one of the foregoing defenses is a waiver of the right to set up any defense that precedes it. But where strong reasons can be shown, especially where the defendant is a person under disability, the court will allow the answer to be withdrawn and a demurrer filed, or a demurrer to be withdrawn and a plea in abatement filed. Each of these defenses will be fully considered in subsequent sections. Article 3. Preliminary motions by the defendant. 233. Motion for complainant's solicitor to show his authority. If the defendant has any good reason to believe that complainant's solicitor has no authority to institute the suit, he may move the court to make a rule on the solicitor to produce his authority. This motion must be based on an affidavit, because the court presumes the solicitor has due authority. The affidavit may be as follows. John Doe vs. Richard Roe et al. Affidavit of want of authority. No. 618. In this cause, the defendant, Richard Roe, makes oath that he has good reason to believe, and does believe, or has been reliably informed and believes, and charges, that Henry Jones, who signed the bill of complainant as solicitor, and who brought this suit and is now prosecuting it, did not then have, and does not now, have authority so to do, and that he is acting as complainant's solicitor in this cause, without any lawful warrant or authority so to act. Wherefore, affiant prays the court to require said Henry Jones to produce and exhibit his authority to act as complainant's solicitor in this cause. With proper jurat, Richard R.M. On such affidavit being presented, and said motion entered, the court will enter a rule on the solicitor to produce his authority. The following is a form of a motion and rule on a solicitor to produce authority. John Doe vs. Richard Roe et al. N. 618. In this cause, the defendant moved the court to make a rule on Henry Jones, Esq., a solicitor o' this court, to show his authority, if any he have, for bringing and prosecuting this suit, and the affidavit of the defendant having been read in support of said motion, on consideration thereof, it is ordered by the court that said motion be allowed, and the said Henry Jones, Esq., is ruled to produce his authority for prosecuting this suit within 5 days or such other time as the court may allow, taking into consideration the distance to the place where the complainant lives, or may be found, or the suit will be dismissed at his personal cost. After the lapse of a term after the filing of the bill, the rule will not be made, unless the delay is satisfactorily accounted for. The authority need not be in writing, and, if in writing, need not be of for all power of attorney, and need not be formally probated. Satisfactory evidence of authority is all that is required. If the authority of the principal solicitor is undisputed, his assistant's authority cannot be questioned. A husband can employ counsel for his wife, and one of several joint contractors may employ counsel for all. 234. Motions in reference to security for costs. If the complainant has failed to give a bond for the costs, or to take and file the pauper oath in lien, or the bond, or the oath on file is fatally defective in substance, a motion will lie to dismiss the suit on that account, and the court will sustain the motion, unless the deficiency is supplied before the motion is finally ruled on. The court will allow the complainant a reasonable time within which to file the bond or take the pauper oath, such time, however, not to extend beyond the term. If the bond or oath is tendered at any time during the term, it will be received, and any order dismissing the suit will be set aside, and the suit reinstated. If the bond has been given, and the sureties to such bond are wholly insufficient, the defendant may make affidavit of such insufficiency, and, on such affidavit, make a motion for a rule on the complainant to give sufficient bond, or justify his sureties. Such affidavit and motion may be as follows. Affidavit of insufficiency of sureties. John Doe vs. Richard Roe et al. No. 618. In this cause, the defendant, Richard Roe, makes oath that John Smith and George Brown, the sureties on the complainant's prosecution bond, are wholly insufficient. Jurat, Richard Roe. Motion for better cost bond. John Doe vs. No. 618. Richard Roe et al. In this cause, on motion of the defendants and for sufficient cause shown, It is ordered by the court that the complainant give a sufficient cost bond or justify the sureties on his present bond on or before the last day of the present term, or on or before the second day of the next term, or on or before some other fixed day, or his snit will be dismissed. If the suit is brought on the pauper's oath, the suit may be dismissed on that ground, or the complainant required to secure the costs, if it be shown by disinterested persons that the allegation of poverty is probably untrue, or the cause of action frivolous or malicious. The motion is usually made to require the complainant to secure the costs, such motion being based on an affidavit that he is able so to do, and the court hears the evidence orally and decides summarily. 235. Motions in reference to the filing of exhibits. It is the duty of the complainant to file all papers and documents referred to in his bill, and if he fails so to do, the defendant may obtain from the master or the court an order requiring such papers and documents to be filed and extending the time for answering until such order has been complied with. Order to file exhibits. John Doe vs. Richard Roe et al. No. 618. In this cause, on motion of the defendants, it is ordered by the court that the complainant file the exhibits to his bill within 2 days, or within some other specified time, and the defendants are given until 10 days after the filing of said exhibits in which to file their answer. If the complainant should fail to comply with this order, the defendants may have a rule on him to file the exhibits by a given day, and, on failure so to do, may have the suit dismissed. 236. Motions by husband or wife to answer separately. It is a general rule that, in a suit against husband and wife, the husband must file the joint answer of himself and wife, or the bill may be taken as confessed by both. If, therefore, either party wishes to answer separately, an order must first be obtained allowing it. The cases in which such an order will be made have already been fully stated. If the facts on which the motion is based do not appear in the record, they must be made to appear by affidavit. Order allowing a husband or wife to answer separately. John Doe vs. No. 618. Richard Roe et al. In this cause, on motion of the defendant, Richard Roe, Rachel Roe supported by her affidavit, she is allowed to answer separately from his wife, her husband. Such an order may be made without affidavit when not contestee by the other spouse. 237. Motions for further time to make defense. If, for any good cause shown, the defendant is unable to answer the bill within the time required, he may obtain from the court, chancellor, or master further time within which to file an answer. Such good cause should ordinarily be shown by affidavit. It is far more easy to get an extension of time within which to answer than to have an order pro confesso set aside. If the master grants an extension, he should enter it on his rule docket. The extension, if granted by the court, will be entered on the minutes, and, if granted at chambers, will be endorsed by the chancellor on the written application and transmitted to the master. Order extending the time for answering. John Doe vs. No. 618. Richard Roe et al. For good cause shown by affidavit, the defendants are allowed the further time of 10 days, or until the day of next in which to file their answer. 238. Motions to set aside orders pro confesso. If the bill has been taken as confessed by the defendant, his first and most urgent duty and task are to have the order pro confesso set aside. When and how this must be done has already been fully stated, but the defendant cannot be too strongly impressed with the following facts. 1. The application should be made at the earliest possible moment, and any delay must be duly explained by affidavit. 2. The failure to file an answer or to make other defense must be satisfactorily accounted for by affidavit. 3. An answer must accompany the application to set aside the order pro confesso, and this answer must not only show a meritorious defense, but must also be sworn to, even though the bill waive the defendant's oath, or though the answer be by a corporation. 239. Motions for rules on complainant to take steps. If a complainant fail to take any step necessary to the progress of the cause, the defendant may have a rule made by the master, or the court, requiring such step to be taken, or the cause dismissed. The grounds for such a rule are ordinarily 1. Failure to bring all the defendants before the court. 2. Failure to revive a suit where some necessary party has died. 3. Failure to amend a bill when leave has been obtained, and the amendment is essential. 4. Failure to revive when a single woman who is party marries. 5. Failure to comply with an order to file the exhibits to his bill. 6. Failure to file a proper cost bond, or a proper pauper oath, in lieu. And 7. Failure to supply lost papers. Ordinary rule to take steps. John Doe vs. No. 618. Richard Roe et al. In this cause, on motion of the defendant, Richard Roe, the complainant is required to take and prosecute with due diligence all steps necessary to bring all the defendants before the court, or all steps necessary to revive this cause against the proper representatives of Robert Roe, deceased. John Doe vs. Richard Roe et al. Peremptory rule to take steps. No. 618. In this cause, on motion of the defendant, Richard Roe, it is ordered by the court that unless the complainant immediately take and prosecute with due diligence all steps necessary to bring all the defendants before the court within 90 days, this suit will be dismissed at the next term.